Thank you. We are hoping that we will be and emerge to be a productive pair. So interestingly, Mary's presentation.
Am I the I or am I the they?
We'll find out.
Okay.
Interestingly, Mary's presentation, I had no idea that she was going to do a presentation on RACI charting. And I was just telling Judge Buckley that in September, our court is going to go through some RACI training specifically around decision making. As you're going to see in our presentation here shortly, we have a lot of decisions to make as an organization over the next several years, and having these sorts of tools are going to be really fundamental to our overall success. So we're going to talk a little bit about the context of this little county called Los Angeles. I'll give you a framework for the discussion of where policy fits within a project. And then just for your consideration, I apologize that the presentation materials didn't get posted. I just noticed that on the website this morning. So if you want it, just let me know and I'll make sure that you can get access to it. But we did seed the presentation with probably about 40 or 50 kinds of questions at a policy level that a court would need to deal with in the context specifically around a case management project. So we use that sort of as a frame of reference. And then we'll talk a little bit about the governance part, right? So putting that RACI charting that you just saw into action and how it might manifest itself in a court. Okay? So first, a little bit about LA.
Right. I realized as we started, before we started, Snorri told me that there was sort of more LA, some people here and Orange County people here. And I guess I'm within throwing distance of Orange County, so I've got to watch out. I thought it was interesting when Mary talked about the example of a state and gave a number of judges. We in Los Angeles have more judges than even the state example that she gave. So it does create a context, if you will, for the approach that we're starting. And we're right at that infant stage of technology implementation. So as we approach this, you can see the number of filings we have. If we were a state, we would be the 8th largest state in the country. The annual budget of 640 million employees, 4,300. Unfortunately, that was about 5,400 just a couple years ago, to show you how the cuts have hit us. And also, we're smack in the middle of it seems like everything. If it's not a Michael Jackson trial with high security and high publicity. Just last week, we were 5-6 trucks outside in the middle of the Dodger case, as well as the Sterling Clipper case. So we have that ongoing aspect of it as well, not only the size, but if you will, sort of the qualitative intensity of the work that we have. So I don't know why people just stare at me from the administration side, but we decided that we had to get intense judicial involvement in the technology approach. I think primarily because we were within months of laying off over 500 people, and then we're going to turn around and start announcing tens of millions of dollars of investment toward technology. And so we needed really a wide range approach to it, if you will, but get our judges on board. So the direction from the leadership, our PJ, and I think our CEO at the time, Sherry Carter, said maybe. So what we did is basically announce to the judges, if you want to be involved in making decisions about technology, if you have input about technology, if you really are someone that doesn't want technology and you want to be involved, let us know. And so our technology committee went from a situation in 2012 not having one meeting because we just were doing nothing at the time on technology because of budget problems, to a quaint little group of 72 judges on the technology committee. Yes, that was 72 judges. I can't get 2 judges to agree on something, and we now have 72. But I actually think, and Snorri may not always agree, that it's been a fantastic experience. And what we're just starting right now, we're in about week 4 of a 7 or so week implementation of Outlook as an example. But the communication with our judges has been phenomenal. The input by judges, so they know what's going on and why, really has happened. And where it really has worked is in the subcommittees. And you can see that we have policy subcommittees, a case management subcommittee, et cetera. And to use the example of the education communication subcommittee, they are actively involved in letting the judges know what's going to happen why it's going to happen, be a resource for questions, and it has allowed a very difficult situation of implementing a whole new email system to 550 judges. X% don't even turn their email on. Think about that. How can you use email to tell people how to use email? That type of stuff. We sat down with our PJ, our APJ, myself, Snorri, and a few others, and we spent 3 to 4 hours talking about how the training session would be for the judges, of how to open up the new Outlook and do the very basics. And it has created a phenomenal approach where really the judges are on board, and they are a partner now with Snorri and his team rather than constantly fighting it. Do we still have judges that will complain? Yes. But they have a place to go, and they're really dealing with other judges and trying to resolve the problem and advancing the technology rather than being an obstacle for Snorri and his team. So that's how we sort of approached it.
So an anecdotal backstory on this was I joined the court in January, and I think almost in my first day, the NACM folks asked if I'd be willing to do a presentation here and what topics I might be interested in doing. And I said, oh, we have to do a presentation on the fact that I have 72 judges on my tech committee. And I think that enough is entertaining to get people in the room, even though we didn't advertise it as such. But it is phenomenal coming from Orange County, which is a large county unto itself, 3 million in population, to Los Angeles. The Orange County judges had a very highly structured governance process. 12 very active judges that participated in monthly meetings, every month. Going from a 12-judge committee to a 72-judge committee is just as remarkable. And what's fascinating about the LA experience is, and I was sharing this with some folks last night, the LA experience, I hope that you don't stop this behavior, but when the policy committee starts to work through an issue, the Orange County model, no disrespect to Orange County out there, the Orange County model was staff would go in, do the research, make a recommendation to the judges, and the judges would sort of vet the recommendation that was done. The LA approach so far has been much more interestingly interactive. They invite me to come, talk to some of the considerations about the policy decisions that need to be made, give them some contextual background for things, and then they go into a dialogue amongst themselves, copying me a lot through email. So these are the judges that do know how to use email. I think that might have been a qualification for joining the tech committee. Although one of the judges showed up with a flip phone. And I said, you can't be on this committee. He thankfully laughed at me and didn't fire me. Yeah, it is interesting to watch how different courts behave, right? So I only knew Orange County experience in my life where it was very staff-driven through a recommendation process and formal decision-making versus an LA model that has 72 judges that are active participants in actually the formulation of the language.
And I think it fits right into what Mary was talking about over the last hour. And it allows the court to really be one, and there's a team approach with the administrators on all different fronts, as well as with the judges.
Okay, so here's the situation in Los Angeles. We have 12 case management systems spread across about 30 or so different configurations and sitting in about 42 separate data repositories. So it's a large court with a lot of compounding, sort of problems through it. Judge Buckley and Sherry Carter, my boss, decided that we're gonna, step on the gas and go full throttle and replace them all, right? So if we're gonna go, let's go big. So we're replacing every single case management system that we have over the next 4 years. We actually stood up.
I thought it was 4 months.
4 years and 4 months.
Oh, okay.
We actually went live with, it's not listed here, actually it's just listed here. We went live with our mental health system, and we did it in rapid fashion, right? So we did it in a little over 2 months, from start to finish. We were going from a legacy system, converted it over, configured it up, had very active participation with the judges and the administrative team, so very much that, that perfect pairing partnership. And it can be done, and we were doing it in a very rapid fashion. The other case types are going to be a little bit more complicated because they have a few million more records in their systems, but it can be done. But we have some interesting challenges in this court as well. So the juvenile systems were deployed in 1981. The criminal system, I think, was 84, and the traffic system was 89, if I have the dates correct. So it gives you a flavor for how old the technology is that is out there. The newer systems are the probate and the civil and family systems, which were at least based on commercially available software at the time. But even within the civil environment, we have some interesting challenges around those systems.
Yeah, so I'm just thinking about how do we operate. And one of the things we did with our huge budget problem was to take all of our personal injury cases downtown. So we took a mere 20,000 cases and put them into three courtrooms, I'm sorry. But what happens is we had 12 districts, and each district had its own civil system, if you will. Again, I'm speaking as the layperson. So when that poor clerk in now this consolidated PI court had to look at a case from Santa Monica, she had to be in one system. Then when she moved to the next case from Pomona, she had to go out and go into a new system. And so whereas I'm saying, well, we can cover 50 cases in a day on the judge mind, the operations are people going, whoa, wait, that poor clerk is going to have to go in and out, in and out, in and out, and it may be 35 or 40 cases. So Judge, you're just thinking unrealistically as to what we can do. And it all comes from multiple systems that over the years, I think tied maybe to the municipal court approach at that time, that they all were sort of their independent technology systems.
Okay, so we're going to talk a little bit about the policy context as you're looking specifically at a case management system, but this would work for any kind of project that we have. So one of the challenges for someone in my role is you'll notice that the demanding captain here is wearing the old wig, and the IT guy is really fit and strong. Right? Just saying.
Hey, you didn't. He didn't show me that slide before we started. I don't know where that came from.
But yeah, so this is the challenge, right? So the 4-month quip, right, was on implementing it was sort of the running joke between Judge Buckley and Sherry Carter and I, where they're negotiating on how many days each Sunday I actually get to not work for the court. But the rest of the time it's presumed that I'll just do it, and it's going to be really easy, and we're just going to make it happen, right? So
we have no jokes in Los Angeles Superior Court.
So what's interesting, though, about case management, and I do apologize if it's a little bit hard to read some of this, but what's interesting about case management, if you talk to 4 sort of separate constituents about what it is that they want out of a case management system, you're actually going to get very different answers, right? So operations is going to want a system that's easy to use, that supports standard processes, that helps us drive to a paperless court. The justice partners are going to want lots of automation through data exchanges and access through portals and things like that. Judges are going to look for everything.
Yes, exactly. Yesterday.
Everything yesterday, right? So they want easy access to information, right? They want useful tools that integrate all of the information that they need to make a decision or a ruling. So that's sort of the context of this, is now all of a sudden what seemed like a simple decision, right? Let's go implement a new case management system, now becomes this sort of interesting problem for the project team because they have all of these different constituents and all of these different expectations and or requirements that they're looking to satisfy.
And I think in the judges, as an example, as you probably well know, is you have the wide range of interest, expertise, and so forth. And so we've already started a preliminary part of looking at what would we want the judicial screen to be, or how would you want that access to be. And you've got some judges that wanted intense information, lots of steps to get everything possible, and then you have some judges that just want a couple tabs and only that. And I also was telling Snorri, I thought it was interesting as to what people different want. A few of us were interviewed by the local legal newspaper, the Daily Journal, and all that reporter wanted to know was the date that e-filing would start. And we would talk about the great website and public access. Oh, that's good. When will e-filing start? And then we would talk about this benefit and the cost advantages and all these different things and let the technical people talk about the different things. And the only question was, when is e-filing going to start? So yes, different people have different priorities.
Okay, so what we're going to try to show here is, and this is what the description of the session is about, is that somewhere between what the expectations are from all of those different constituents and the technical solution that you decide to go with from a core perspective, whether you build it yourself or buy it from a vendor community, is ultimately sort of foundationally based on good policy and a good policy governance process. Okay?
So we have then the definition here, proscribed course of action, which is to be followed with, and then each of these are separately but also connected. The acquisition, the deployment, the implementation, and the use of information or technology resources. And so the direction we've been given from our PJ, and as we heard from Mary, there'll be a new PJ come January, et cetera, but is that the technology committee through the judges be involved with the policy implementation for each of these. And so again, it adds to the challenge, I think, to Snorri and to Sherry Carter, but that we, as complete lay people to this, work closely on the policy. And we have already sort of worked on some of the policies, the acquisition. We had a specialized subcommittee. So we had about 30 judges be involved in the presentation by prospective vendors, had breakout groups by case types as to the approach, and really had a policy approach to how to select, ultimately a recommendation to the CEO and the CIO, but nonetheless an active involvement as to the policy implementation of the acquisition, and we're going on to these other steps.
Okay, so what we thought would be interesting was to just give you a whole smattering of policy type questions that you might have to consider in implementation of a case management system. And again, we'll try to look at it through the lens of the sort of 4 constituents that are out there, but these are the broad areas. So operational sort of policy questions, technology policy questions, access, privacy, and then the revenue generation, or cost recovery, depending on how your court operates. Okay, so some operational policies. Like I said, what ops is typically trying to drive for in a case management system is they're driving for uniformity and consistency, right? That's what I love about RACI charting. So in Orange County, when RACI charting first got introduced in like 2006 or so, the IT people looked at it and they were just sort of baffled by it. They were like, what is this RACI charting and how does it apply to me? Gave a presentation to the operations folks, and they thought they'd found the holy grail, right? This is the thing that makes sense because operations people are very uniformly driven through procedures, and they want to know specifically who is the person that's accountable for making a decision, and who needs to be consulted, and who just needs to be informed, right? So those are the framework, right, and the context that operation people are looking for, but to get to that uniformity, there are a whole slew of policy questions that you have to address. Will the court adapt its business practices to what the case management system can do? How much data will you convert? How much data will you retain after you've converted that information? Are you going to try to use this case management system as an opportunity to go to a paperless case environment? Are you going to backscan? If you're going to go to a paperless environment, are you going to go start backscanning, many years worth of cases? Is it going to be just the active cases? Do you have a procedure for dealing with a case that comes before the judge that is still partially in paper, and the paper is sitting in the archives office, 30 miles away, right? So you have to start to think through all of those things, because in the mind of some of those constituencies, right, that is what defines success in a case management system.
I think when you talk about judicial uniformity, you're talking about an oxymoron. And so the challenge that we have in any court that you're going to have as well is how to adapt those processes and get a uniform decision. The very first thing we try to do is do an online reservation system, very basic. And already it has created these issues. Some judges want X number, I would say 2-3 motions, heavy motions a day. Some want 5. We hit a big snag just a week ago when we moved on to Santa Monica, and we moved the cutoff time for the change of the reservation to 3 p.m. the day before. And it threw some judges that had been doing a different system into a tizzy. They just couldn't understand how that's changing so late in the game for them. And so it's going to be, obviously, we multiply it by 550, but every one of these is going to be that ripple effect as to how there's acceptance and an agreement.
Yeah. One of the other interesting questions around the new case management system is the complete level of involvement from the operational side So, the operations staff in LA, right, if we're going to replace every single case management system in the course of 4.5 years, 4 years and 4 months, 4 years and 4 months, you actually need to start pulling operational staff into the configuration of the system and the testing of the system, into the design of the system and all of those types of things. So a very interesting policy question that the court needs to make right out of the gate is, how are we going to do that? Are we going to backfill the staff that we pulled to make dedicated to the project team? Are we going to just use the project team, have them work overtime, try to fit it into their day job? I mean, it's a very, very big, important decision that the court needs to make almost immediately, out of the gate. And it's very related to that sort of first question up there, which is around how much of your business are you going to adapt to what the software can do natively, or are you going to drive towards customization? And that sort of drives into some of the technology policy decisions, as well. That customization question, is really, really paramount to a successful implementation, right? The more you customize, the greater risk you have in successfully implementing the product. On the other hand, you may just need to customize it because your court runs differently than the standard national model, that exists out there. So, from a technologist perspective, as you're implementing these things, we're immediately starting to worry about, okay, do our existing IT policies need to be changed, the customization? Am I going to be, as the CIO, burdened with adhering to national or state standards with respect to the technology? As we start to move to this paperless environment, how much downtime is going to be acceptable, right? So if there is no paper record to rely on when the power goes out, how does the court function, right? So I need to know that. Of course, my answer is going to be, he's going to say, I want it available 24/7, and I'm going to say, give me $1 billion, right? And I can get it there, right? So there's a policy tension that emerges right away, right? What is the appropriate level of risk, that we'll deal with? You can even drive down to specific things around security, right? Are we going to allow different people to have different levels of access? Maybe a juvenile social worker in the child support agency in the county needs to get access to the juvenile record, right? But her supervisor may not have any access because it's inappropriate based on court rules, right? So you have to start to think about those sorts of implications, and then also whether or not you want to drive some performance standards on the vendors.
Let me throw in again an advocacy for this 72-judge committee. I don't know what this screen means, really. I mean, I think I do, obviously, but Snorri is not only identifying questions I could never think of, but he really knows the right answers and so forth. And so what's going to happen, I think, over the next 4 years and 4 months is to have the judges actively involved. And I'm not saying, I hope we'll have a blank now in the tape of this, but you got to deal with judges in a certain way. Maybe you deal with your children in a certain way, maybe you deal with whatever. But if a judge knows that some of his or her colleagues have been in some meetings about the customization of the system or the planned system of downtime or whatever, when we get to the actual, okay, judges, here's how we're going to be doing it, there's going to be a buy-in by the fact that there's been 72 of the colleagues involved. And it's really going to be directed by Snorri, but I think that we're going to have, an open-mindedness as much as possible with 550 judges. But nonetheless, since we're in it from day 1 to day 2, and we're providing input, it might shift Snorri's approach here and there, but Snorri will get where he wants, and I'll be able to tell the judges we did it together.
So access policies are very interesting because everybody is expecting with the new case management system that they're going to get perfect access to information tailored exactly to their individual needs, right? So the judges are expecting all the information that they want from a case perspective. The public has expectations already about what access to case information you're going to get. The justice partners are an interesting group as well. So as we started to socialize the change with the justice partners within the county, there was sort of this move between excitement and trepidation, right? Because we have a system that had been running since 1981 in the case of juvenile, right? You can imagine the anxiety levels that went in there because, boy, that's a tried and true process, right? We know that works. The flip side to it is there's a lot of frustration with the fact that the system is inflexible and it's not very adaptable and has its other sort of challenges. But the access policy questions are really very interesting because you have to figure out, who are we going to share the data with? Are we going to have different policies for case data that's going to be shared inside the court, outside the court, right? So a lot of talk on the practical obscurity stuff where you can share more information, at a courthouse. Are you going to change your access policies relative to this different case types, right? Juvenile is an obvious example of, where you have higher restrictions. Will you implement e-filing? Will you make it mandatory? Will you move to a paperless court? These are all sort of fundamental access questions that the project team is going to need to have be made relatively early on in the cycle, right, in order to have a successful case management system. Okay, privacy?
So privacy policies are going to be a very challenging part for our court because we have really not dealt with that. We have just started having some meetings on some of the issues of privacy and realized that maybe some things have been going on within our court and we've not addressed the issues of privacy outside the realm of technology. So we're going to have to really look at these questions of who is subject to the privacy policy and how will they know and so forth. You want to talk about the MOU approach?
Yeah, so one of the things that we've started to do as the court has now started to share this information, so even off our legacy systems, we do have the ability to share information, but the court historically had not taken a sharing approach. So Sherry Carter comes in as the new CEO. Even before I got on board, had started plowing that road to say, okay, we're going to share information with the justice community. So she had our court counsel draft together a formal MOU. We distributed it out to all the state, county, state, and a handful of federal agencies around the sharing of criminal information, just as a for instance. And it was a formal MOU, right, that said that they would behave, they understand that this access was being provided at a convenience, the official court record was at the courthouse, right, you're not going to hold the court at harm if bad decisions are made. So it had all of that language in it in a very, very formal construct, right? And at some level you intuitively, instinctively feel, oh gosh, that's just really bureaucratic and formal, but absolutely zero resistance, right? So the community, the good thing about not providing any information for 30-something years is when you go at them with, here are my terms and conditions for access to my information, they immediately turn around and sign it, right? So very exciting. We're moving very quickly in that path. But what's interesting is you have this sort of broad MOU sort of contract that you're establishing, and then you have individuals that work within those agencies. And what is the mechanism that you're going to use to hold specifically John Doe accountable to access to that information? And of course, if you overly bureaucratize it, if that's a word, it creates work for court staff, right? Someone has to then maintain all of these records. And so Orange County Court actually has done some very interesting things around automating some of that flow of user registration, right? So you sign the broad MOU that allows people to then come in and self-register their work email address into the system, but then they have to provide a supervisor's email address also from the same agency, and then a automated system workflow goes out there every 6 months or so to validate that John Doe is still an active employee of that agency, right? So as opposed to relying specifically on the agency to keep their access lists maintained, we've actually found a way to start automating that flow without any labor, right? But driving down from broad agency MOU accountability all the way down to individuals within that agency. So there's a lot of things that you can do from a compliance level, but again, it has big implications on your case management system implementations.
So within next one.
There it is.
So within California, we have some statewide committees through the staff of the Judicial Council. And so one is called CTAC, and it deals with the court technology, which I'm a member, and I believe Snorri will become a member soon. So that group is actually implementing a model privacy policy, and coincidentally, I'm actively involved in that. So the goal would be is that through the statewide committee, we will provide model privacy policies for the individual courts. And I'm sure it's the same elsewhere, but you have not only that independence, if you will, of the individual judge, you have that independence drive for the individual courts. And so the hope would be that then we allow the individual court to have its own privacy policy. The larger courts will probably have the resources to create that as well as implement it. The smaller courts would have to rely more on the staff for the Judicial Council so that that model would be more maybe adopted across the board by smaller counties. So I think that's how we would look about setting the policy, both state and local court in California, and then allow the individual courts to do the education and the auditing.
Yeah, and those are sort of three key pillars in the governance around policy is, who sets the policy, who makes that decision, how do you educate people about the implications of the policy, and then to what extent are you going to actually go in there and monitor and enforce, right, and create these auditability trails. So anecdotal story for my Orange County days was we created a system called the Criminal Defense Attorney Portal. So the DA and public defender all had wonderful access historically to the criminal case information in the court. The private defense attorneys did not, right? So they could access the same way the public did, but they couldn't drive to that same level of visibility into the court record that the DA and the public defender had. So immediately they cried, foul, right? We've gone out of balance, right? So we immediately commissioned a project to go in there, put in that capability to give them sort of unfettered access to the system, which is what they were asking for, right? So if a person is coming to ask them for a case, they want, even though they're not an attorney of record on that case, they want to be able to do some background information on that person, right? And the court in Orange County decided at a policy level that was completely an appropriate use of the system. But we did also institute an auditability record in there. So every attorney had their own unique ID to log into the system, and every time they accessed a record with their ID, we put a little fingerprint, right, a breadcrumb in the system so that we can do it. Well, guess what? One of these attorneys decided that, oh my gosh, I have access to the court database, and Orange County uses a lot of red light cameras, and I want to know every single person that got a red light ticket. And I'm going to go start mining that data, that's in there, and I'm going to start prospectively, going out and soliciting legal services to say, hey, I can get you out of this case, right? So the DA calls us, and the Garden Grove Police Department calls us and says, hey, we're getting a lot of complaints about a particular attorney going in there and soliciting, business. And we're wondering if you can help us find it. And sure enough, typical attorney, accessed the system 3 times a day, 5 times a week, right? And then there was this one guy that was out there that was accessing it 200,000 times in a month, right? So he had people going in there and running through the case records, right, and jotting down the names and, making it all happen and doing the solicitations, right? Well, of course, bad things happen to that person, but it gets into the point of it's one thing to make the policy decision, it's actually another thing to actually follow through with it, right? So we educated the legal community that we were doing this, and then we actually came through and followed it up with, with the audit records, right? Handed it all over to the DA. It was very fun. I walked up to the PJ's office, handed him a thumb drive, and said, here, you can go give this to the Garden Grove Police Department and the DA, and have a nice day, right? And he was really happy because he really wanted to get these guys to stop doing that. Okay. Okay, so policies around information, right? So what information will you share? What information won't you share? So in California, the California rules of courts are very specific about what you must share, right? Which is sort of what they call case index data, right? Case number, case name, parties to the case, date it was filed. They have specific guidance on what you can't share: driver's license, social security number, financial information, and then it's completely silent on everything else, right? So that's all then left to interpretation, right? So, but that's something that you need to sort of wrestle through, as a court. How much information are we going to share? Will different people see different information? Parties to a case obviously should be able to see more information than somebody that's just snooping around and interested in things. How fast will you share the information? My anecdotal story here is Orange County had an integrated justice community, and I kept telling the chair of that committee that I'm sending you the information real time, right? And to me, real time meant the second it hit my system, it was pushed out and made available to his system. And he kept telling me, Snorri, it's not real time. I'm not getting this information for 24 hours later. I said, that's not possible. I know that my data's coming in there, right? So then I walk over and I ask the court operations person what was going on, and she says, oh yeah, we don't keep real-time minutes in the courtroom. These are really administrative things, right? We don't have to work that fast, right? So then I had to go back with egg on my face and said, well, technically I was right. I'm giving it to you as fast as I get it. We're just not putting it in as fast as you want it, right? So those are things, though, that you have to sort of wrestle with. Will you sell bulk data? And then how will you share the information, right? Because again, that justice partner community down there in the lower left, they want access through interfaces, they want access through portals, they want access every way possible.
And again, we're just starting on this vis-a-vis Los Angeles, and we're just starting to look at different things. And as you well know, I'm just telling things that are anecdotal to LA, but we had a big issue with Michael Jackson's will. And apparently it is somewhere in Los Angeles County, and we'd have to kill you if you knew where it was. But again, to have access to that in electronic form might be completely different than to get that original for someone to look at it, be able to touch it. The other thing, again, I know it's elsewhere, but the media wanting that immediate access and that issue of quality control. And are you going to have that quality control as far as the filings and so forth of that day's filings? And maybe even electronically, it might be less, or I should say a little bit longer for the media to get access to that information. So that's an ongoing tension, if you will, as far as the fast information.
Okay, so segueing over just on data quality, now you have a whole set of questions that you have to deal with about, what checks is the court going to put in place with this new case management system relative to the quality of the information that's going to be captured, right? So some of the older case management systems, right, you just free texted everything that was in there, right? So you just captured minutes and that was the record. Modern case management systems are very code driven. Those codes trigger actions and workflows and events and a whole slew of things. So the burden on quality, not that is more important now than it was before, but the consequences of bad quality data are more significant, especially if you're doing those real-time exchanges with justice partners. So you have to start asking those questions around, what procedures are we going to put in place to ensure the quality of the information, even beyond the fact that you have edits on the screens and things like that. You also have to think about the fact that no matter what you do or how much effort you put into ensuring quality, stuff is going to happen, right? I mean, it's human beings. We're going to make mistakes. Us computer people haven't taken over the world completely, so we still need you carbon-based life forms to do some things. But so when a mistake is made, how do you notify everybody, right? That's happened, right? That's a policy decision that you're going to have to make. Are you going to be transparent and immediately share it? Or are you going to sort of huddle up and try to figure out a way to spin the story, right? Those are big questions that you have to make. The validating the information as it's coming into the court was a fascinating policy discussion for me in Orange County. To me, it's like, well, of course, if I'm going to build an interface with the DA, for example, I'm going to ensure that they cannot file anything that is inaccurate, right? I'm going to build every edit in place to know that this thing makes sense, right? And the judge looked at me and says, no, you're not. I go, what do you mean, no, I'm not? I go, I have to make sure that the codes go, and this code goes with this code, and things like that. And he says, no, the attorneys get to decide how they're going to file it, right? So now I have to make an accommodation in my system to allow something to come in that I know is wrong because it's the attorney's responsibility, not the court's responsibility, right? But those are things that you have to sort of wrestle through as you start talking about these data exchanges and connecting it, right? So data quality can both be your staff, but it can also be source systems from other agencies. And then you get back to that whole question around balancing data quality, right, with speed of information, right? So you could put a comprehensive data quality program in place where you have people going and examining all the records that were entered in for the day and have a week backlog before the information is available. That actually may create other problems for you, right? And you may not even be able to afford to put that level of quality assurance into place. So a lot of complications, yeah. Yeah, so the question was, this conversation was more prospectively about the new system and the quality measures that you're going to put into place, but what are you going to do about all of that legacy data that you need to convert across? And there's going to be problems in that. And it's a big deal, right? And so I think that was alluded to in the operations policies above in prior slides where it's, how much data are you going to convert? How much do you need to convert? How much do you want to automate the workflows on those legacy things where there may not be sufficient amount of detailed data available in the case management system to trigger all of those workflows and activities that are going to be there. I mean, these are really big policy questions, you know, that you need to deal with, right? So I don't actually have a, you know, a magic answer for anybody on what's the right answer, right? How much do you convert or not convert? My general perspective has always been convert it all, but every one of you has lived through a bad data conversion project, and you're wounded and scarred by it, and I understand that. But sometimes you have to get through those 5 stages of grief and move on to acceptance, and you know, things to get better. We're a little bit smarter now than we were, you know, 5 years ago, right? Or 10 years ago when we last tried to do that. But it is a difficult project. So I know right now in LA, they're going through right now and starting to look at all of those records, right? We're trying to identify where we have information that is not accurate. So I just got an email this morning that the DOJ only accepts so much information. We're restricted to like 6,000 transactions a day or something like that. And we've been going through this big data purge project, right? Where we've been cleaning up our old records, case file destruction project. And as they were going through that, they started to identify things where we didn't complete the entry correctly, right? So we're now putting in the disposition information, which automatically creates a trigger event to send to the DOJ, right? The DOJ now is facing a backlog from the court of, I think it was like 60,000 records or something like that, because their system can only process about 6,000 or 8,000 of these things a day, right? Those are really big problems that you have. When you start to clean up the data, you're going to create problems with your existing system while you're trying to get ready for the new system. So yeah, these are big problems, right? So the real win in all of this, honestly, is having the discussion, right? So ensuring that the judges, the court leadership, the administration is all aware of the fact that we have a problem, right? So bad news doesn't get better with age. Let's find the problem, you know, quickly. Let's start to work through it and try to collaboratively solve to it. You won't be able to solve all the data quality issues that are out there, but you'll be able to make a dent in it, and you'll have a whole lot of tough decisions to make along the way.
And on the data quality, and using more the layman's term of it, at least in LA, if we're objective about it, there's probably somewhat of a distrust by the judges as to the quality of the not the data, but the presentation of it. So for example, the elementary technology that we have for our civil judges is that the documents are scanned and they're going through an OCR. And invariably, many of the captions are, you can't read them. It's instead of Smith versus Jones, it's Smitty versus JJ or whatever it might be. And so I think what you face is going into, again, a conversion, if you will, or anything else, is there's sort of a distrust. You know, are you going to really be able to do this? And so what I want to emphasize is that that first step, whatever it might be, for us, it's this Outlook conversion. You just got to make sure that you do it right, you get the confidence and the trust of everybody, not only the judges, but the staff, that there is talent here and we're going to be able to do it.
Okay, privacy policies around sharing. So will we grant expanded access to individuals? So I used that juvenile social worker example earlier, right? So they probably have a right to, in a foster care context, right, see additional information that we historically wouldn't have granted them. The court actually faces a huge problem right now. So again, the justice partner community in the County of Los Angeles is aware that we're replacing our case management systems, and I'm getting bombarded with requests. Snorri, we want to build this interface, you know, with Child and Family Services. We want to build this interface with the DA. We want to build this one with probation, public defender, alternate public defender, right? They're all knocking on the door. LAPD alone submits, you know, like 600,000 or 700,000 traffic, you know, tickets a year, right? And they're like, hey, if you're going to build a new system, we want to implement a new e-citation, you know, protocol. It's like, great, love it, but I have a fundamental problem around priorities, right? Right? Who's going to decide which interface we go with first, right? You cannot possibly do them all. You're not going to wait until they're all done before you go live with your system, probably, right? Policy decision. But those are the things that you have to sort of start dealing with as you're sharing the information, you're disclosing the information, and you're going around, you know, things like the audit trails.
And with that, we're always conscious of what the statewide approach is going to be. And if we're going to start dealing with certain agencies, are we going to dictate or exclude other counties and other courts? So we have to keep that communication going. Also want to take a moment and emphasize that audit trail. and how it could tie into some very sensitive and critical issues as to judicial elections and so forth. There's a trail being created. So we were in a meeting, it seemed to be very a minor point of how much access would other judges have to court files. So if I'm working on a civil case, could I access Judge Smith's case? And so at one point everyone was saying, well, okay, but there's got to be an audit available. We got to make sure that I know that Judge Smith looked at that. Well, then Snorri points out, okay, fine, but then that creates a trail all around. And therefore, if someone really wants to find out, Buckley, did you read my opposition when you ruled on that critical motion? Well, the audit trail would show whether or not Buckley opened up that opposition and therefore read it. And so quickly the judges go, oh, no, we don't want that trail. I don't care if there's a trail as to the other judges seeing my file. But the point being is that we as lay people don't even think of the issues that Snorri has dealt with and or thought of, and we are always trying to protect public access to certain things, 170.6, et cetera, that people might want for the next election.
Okay, revenue policy. So this is a very fascinating one. So Los Angeles was one of the first courts in California to actually start charging for information. And they came under a little bit of scrutiny and fire for it, a dozen or so years ago. And then they were turned out to be completely justified in what they were doing, right? In order to make this information available for people to consume it, it requires a lot of effort on the court's behalf to make it happen. So the court has done this, right? So I was at Orange County. We followed the Los Angeles pricing model. Sherry was at Riverside, County, adopted the LA pricing models, and then Sherry, being a little bit of a maverick, decided that it might not be good policy to charge as much as we're charging to get access to this information. So she decided to move, like for access to civil documents, for example, the very complicated formula is $7.50 minimum to buy a document online. That includes the first 10 pages, and every page thereafter is 7 cents a page, up to a maximum charge of $40, right? So very complicated formula, right? And Sherry said, well, in reality, most people just want to buy the first 2 pages, and the barrier of entry is too high at $7.50 for access to the document. What if we changed it so that our online practices mirrored our in-court practices, right? If you come to the counter and ask for a copy request, we're allowed to charge you 50 cents a page. So she immediately dropped the price to 50 cents a page, right? So the courts around the state were fascinated in watching this, right? Because we're going through a budget crisis. This revenue, cost recovery, right, that's out there was funding a lot of our new initiatives that we were doing to try to improve and expand upon access. And here you have this crazy CEO, hi Sherry, that's out there.
Well, that's another blank in the tape.
That's dropping the price, right? And it's like, oh my gosh, what is she doing, right? So I'm on the phone with the CIO in Riverside, and we're monitoring it like crazy. And guess what? The revenue to the court did not drop at all. Access to court records, doubled, right? Public policy is that's a good thing, right? You're increasing access to information by the public. She did it for the noble reasons on it was the right thing. It also had this, nice benefit on the backside of, okay, all of a sudden now court CEOs and CIOs are worrying about price sensitivity models, right? If I lower the price over here, how's it going to impact my sales, right? I mean, who talks like that in a government setting, right? Nobody does. But that's what you have to start thinking about, because when you have all of this information, you have lots of people that want to get it from you. And what is the court's obligation to make that information available, and to what extent can we recover, the costs to that? You get down into some interesting questions around exceptions, right? So in Los Angeles, if you want to do a name search, right, on a person in a criminal matter, you have to pay a fee to do that. But really, if you're the district attorney or if you're a cop out on the street that wants to go in and do a name search on this person, we probably shouldn't be charging for that, right? They're a government agency, right? It should be part of the, the family, if you will. So now all of a sudden you need to create policies around the fact that I'm going to build these systems that's going to make information available. Oh, but there may be this subcategory of specialized users that we're going to grant free information to. That's awesome, right? Has a cost in terms of the project workload and potentially the project schedule. So it's for 4 years and 5 months. So things to think about relative to revenue.
And on that, again, I don't need to tell you this, but we're all dealing with access issues across the board. So what we did in Los Angeles, again, is we consolidated so much. So we went from 26 courthouses that had small claims courts down to 5. We went from people having an average of 2 or 3 miles to get to the small claims case to up to 15, 20, 25 miles. And that applies to UD, same numbers almost, 26 down to 4 courts. And so
And
again,
this is Los Angeles, so the difference between 2 miles and 10 miles is 3 hours.
it could be. If you know the LA, to get from the outside of the valley to Van Nuys is one drive, to go from there to Santa Monica to your UD court. So whether to have that ability to do the filing, and it goes across really everything we've been talking about, but that we have taken down, if you will, some of the services that we provide to our constituents based on number of courthouses, the access and distance and so forth. So the use of this technology is going to only increase, and it's much more vital to our service.
Okay, so we're going to now bridge through how do you wrestle with some of those types of decisions and any others that you can come up with and get to a framework around making decisions, right? I mean, so fundamentally, that is what governance is all about, right? It's a means to make good decisions, right? So very, very simple definition of governance. It sounds like this bureaucratic abstract term, but it really is quite simple on what you're trying to accomplish.
And I think if we heard Mary talk, I think it really addresses a lot of this as far as the objectives and so forth. In a next slide or two, we'll be talking about the structure of the PJ and the judicial leadership and the CEO and the operations, the people that will be there for decades and so forth. And so as you're trying to, with this 72-person committee, try and provide clarity and collaboration and so forth, you're still dealing with the individuals that are out there. And so as one little example, we were working through the process of the whole effectiveness of governance of how to deal with the domain name. We were at lasuperiorcourt.org. And so with these changes, we thought we'd get to lacourt.org. Just every time I was typing S-U-P-E-R, I was just cringing on that. It took one judge who heard it third hand that we're going to lose our domain name and therefore we will never get an email again from that old thing. One judge calls the PJ, who then calls me into his office of what the heck is going on here? Why aren't you communicating? And we are. We're working with 72 judges. We're working with Snorri. He's given us the input. We're doing the collaboration, but someone's out there trying to express a complaint, and then the PJ calls us in and we slow down. So you really got to, I think, bring the governance into its overall structure and allow it to work itself out. And you got to tell that PJ, let it work itself out.
Okay, so how on earth is Los Angeles going to replace all of those case management systems, in 4 years and 5 months? Especially when you have different sorts of governance challenges within each of the case types, right? So in a normal model, you would have a project team that would escalate sort of policy decisions up to an executive team. But when you're running, 5 projects concurrently, in this example, you now have some interesting case type specific policy questions that might need to be wrestled with that are more appropriate to let the supervising judge of civil try to form a recommendation for the PJ to make an ultimate policy decision on, as opposed to a single judge representing happens to have a criminal assignment making policy decisions on behalf of juvenile or family or civil, right? So that's sort of the challenge. And so one of the advantages of being a large court is you have scale, right? So you can start to form multiple teams, and very simplistically, we'll actually start from the bottom up, right? Because what's supposed to happen in this model is policy issues get identified down at the root level, right? Where the work happens, right? So in Mary's RACI model, right? These are the people that know what's going on. They're the responsible people, the doers that get things done. But they're recognizing there's a dissonance. There's a challenge in the way that the system is going to work. And so they need to start to bevel those issues up and get them formed into policy questions that can be dealt with at higher levels as you move up that change. So what we've decided to do in Los Angeles now is to then form these case type specific intermediary steering committees, right, that will meet, probably, and I'll talk about this in a subsequent slide, but they'll meet, maybe once a month, where the project team will relate up to the family judges, the judicial team, right, that's going to be making those recommendations, what the issues are, and bubbling it up into the form of a recommendation up to the top of the organization, right, which is, this cross-section of administrative staff and a subset of the judicial leadership, right? So that's the flow, right? Issues go up, recommendations gets made, and then as decisions get made across that that group from the leadership down, right, you push the decisions down and they get implemented. Seems complicated, seems bureaucratic. I have a ton of experience working in this sort of framework, from my past lives, and it works really brilliantly if you commit to it, right? You have to be committed to the fact that we're going to raise issues up quickly, we're going to have constructive dialogues around things, we're going to be completely transparent with what we're facing, so that we can help the decision makers make informed decisions, right? That's ultimately what they want to do, right? They can make a decision, right? No, we're going to keep LA Superior Court, and they're going to, or they can say, no, we're going to make a decision here, but they want to know the parameters, right? What are the objectives, right? What are the objections, right? What are the concerns that live out there, right? So that's very important to, the process.
And if you could leave that slide just for a second. Again, what I think we've done now is that we had judges that were one of two extremes. We had judges who felt there was no word judicial or judge here, that they had no connection whatsoever to what's happening and what would be decided, and or I should say, they wanted to be right here at the bottom every step of the way, which would be just asinine. But nonetheless, they would insist on it. Okay, I'm a judge, I can say that, right? But because we went over the last year and maybe had some birthing pains with it, but we've now created, I think, a culture whereas the judges have a confidence in the system and know that their voice will be heard at the right time. And so I think we are adjusted now that we'll be right where we're supposed to be. It'll go so much faster, much more efficiently, and maybe we make it down to 3 years.
I got to do the math in my head. 3 years and 17 months.
I went to law school because I didn't want to do math, so I'm not going to worry about it.
Okay, so a little bit of an eye chart. Sorry, this is the left brain side, right? This is for you visual people, which is me. Here's for you left brain people. It's mostly operations folks and finance people, right? But here's more or less how they work, right? So the executive team from administrative side is the chief level. And the judicial side is the PJ, APJ, and then the tech committee chair, which would be Judge Buckley, right? So this is the group that's empowered to make official policy decisions on behalf of the court. Within that framework, there are some decisions that are exclusively the domain of Sherry as the clerk of the court, right? So she has the authority to make those decisions. There are some policy decisions that are exclusively the domain of the judges. So this committee does not have to make all decisions, right? But part of the process will be to recommend it up and say, okay, whose decision is this? And these are the people that will make those policy decisions. As you're down into the case types, right, you'll have a cross-section of operations and finance and IT people involved with a handful of representative judges per that case type to deal with the recommendations and the issues that are coming up, from the project team. The advantage of this model is twofold. Not only does it help in decision making, but as Judge Buckley alluded to earlier, it helps in the change management and the buy-in of the systems when you roll it out for 4 years and 6 months later. I'm trying to buy an extra month.
He'll be at 6 years by the time we're done.
Because they've been involved every step along the way, right? They have ownership in the decision, right? If there's an objection to a decision that's being made, they will be highly educated on why that decision was made. They'll have context for it. So these are really, really important. So you do not want to underestimate the importance of this managing change for the rollouts of the different case systems. So what we're looking to set up in Los Angeles, I mean, we haven't even kicked off our case management projects. They all start kicking off in a couple of weeks. Is this group here will probably meet every 8 weeks. If decisions need to be made in a more rapid fashion, we have a process of escalating those issues up. The case type teams, right, probably meet every 4 weeks or so, about once a month. right? And then, of course, the project teams, right, will meet in a very formal manner on a weekly basis as they continue to drive this, this project forward. So it's a good model, as you can see from Mary's presentation, right, going through the exercise of every one of those policy questions that you identify in doing that RACI model charting, right, whose decision is it, right? Is it a administrative decision on the sequence of the screen, the fields in the screen? Well, that's probably at the, the clerk level to decide, right? They're the ones that use the system. They get to decide the order of the screen, the data fields, right? Or is it a policy decision, right? Are we going to charge for access to information, right? So figure out who is the accountable, and there can only be one person accountable for every decision. Who is that accountable person, and what information and support do they need in order to make those decisions? And you'll actually be in pretty good shape. So last slide before we'll entertain a few questions if there are any out there, just sort of bringing it all together. Every project has some sort of policy implication surrounding it. A lot of courts have a mistaken approach where they treat these things as technology projects, right? So I've made the decision, right? Make it so, hit the easy button, and it happens, right? You do not, I am telling you, you do not want me to make policy decisions that are going to impact the way that you guys operate, right? It is just a train wreck. I think I'm a reasonably intelligent guy, but I have no idea how the court operates truly. At a detailed level. So you have to treat this as a business project, right? So I know I'm preaching to the choir, you all know that. And the successful projects are the ones that take a very proactive management stance and actively manage the policy decision-making, process in every way. So if you want to be successful, actively identify and discuss policy questions throughout the project's life cycle, and then establish those governance processes, along the way to ensure that decisions are being made at the appropriate speed and quality level that your organization wants. And I think with that, are there any questions? Yes?
Have you selected a vendor for your CMS?
So the question was, have we selected a vendor for the CMS? We have selected one of our vendors, and there was a press release on that one. We are in still negotiations with the second vendor, so we're not going to tell you who that is, so you just have to wait till that press release shows up. But
You're going to use more than one vendor as a solution?
yes, yeah, and so there's that was also a very interesting policy question that the court went through, right? So at some level, there's a sort of desire to get to uniformity, and at the other level, there's a desire to have a higher degree of customization and configuration, right? And so it was a balanced trade-off. And we actually went through and made our case management decision on a case-type by case-type basis, right? And so those judges and influencers from the administrative side were involved actively in that process.
So the two-vendor solution was based on integration with the existing legacy issues. Instead of selecting one and integrating one solution with all 12 CMS, you based it on what was easier in terms of being integrated into your legacy system.
Yeah, I mean, it's a little bit more nuanced than that. I don't want to bore you with all the details, but we basically had 4 vendors that we could purchase against. Of those 4 vendors, only 2 of them could deal with the size and scale of Los Angeles. So then that made it a very binary decision. So by each case type, do you want to go with the legacy, or do you want to, vendor A or vendor B? In one of the instances, right, the new vendor was also the legacy vendor, right? So that's a hint.
But we really did if you go back to some of the prior slides and you look at the various policy considerations, I think a fair number of those considerations were part of the decision. And I agree with Snorri that it would be nuanced because it had a lot of overlapping and nuanced issues.
Yep.
How many judges are on each subcommittee?
How many judges are on each subcommittee?
It varies, but about 10 to 15 on some. On the case management vendor selection, we had about 35. Basically, we said anybody can be on that subcommittee, but you have to show up to the presentation. And then once you didn't show up, then you're on that. But it's about 10 to 15. We have not started yet a budget subcommittee that I probably will keep below 10. And the policy and priority 1, which I think will be ongoing, is probably about 12 again, but the others are a little bit higher.
Yeah.
Are you going to combine some of the case management systems to reduce the overall number of having 12 separate systems?
Yeah, so the question is, are we going to combine case management systems to move from 12, which is actually 20, which is actually 42 separate data stores, to 2, right? So we'll have one for one group of case types and another for another group of case types, yeah. So we'll definitely move to that more simplified world in 2 years and 470 months from now. Yeah.
Are you guys be using the cloud to manage your network, or will you guys monitor this yourself?
Yeah, so the question was, are we going to be using any cloud or managed services from the vendor community to help us in this action? Yeah, we have a scale problem in Los Angeles, as you saw in the numbers, and so we are deciding from a case management perspective to host all of the information locally within our county, but we will leverage cloud-based resources as they sort of manifest themselves through interfaces, and certainly through some monitoring solutions of the lower end technology. But at this time, the intent is to do everything on premise within the county for the case management system. Yeah. Yeah, so the question is, does the court have a policy on social media and the use of, for example, texting? So the quick answer is no, we don't, but we know it's one of those areas that we have to wrestle with, not necessarily in the context of a case management system, but there was a great paper, Norman's somewhere in here, there he is. Norman wrote this awesome paper on social media and the implications of it, so go talk to him if you want to get some great insight to it. But it is a really interesting problem for court to deal with. And a lot of courts struggle with just what is this thing called social media, even though it's been around for 10 years now. No offense to those of you over a certain age, but it's a sort of foreign concept to you, right? You have these little kids that just speak in 140 characters or less, right? And so their minds work differently than ours do, but it is a very important issue. But Norman's the expert in the room on social media policy.
May I conclude with apologies to a few of you. We are so excited to have Snorri with us in Los Angeles, and you can see we will succeed because of his leadership.